If you thought 2025 was the year you could still use that old Social Security trick to collect one check now while quietly letting your own benefit grow bigger in the background, stop right there, because that door is effectively shut. And for a lot of seniors, the painful part is not finding out too early. It is finding out too late. By the time many people hear about this strategy, the window is already gone, the claiming decision is already made, and thousands of dollars that could have changed a retirement plan are no longer recoverable. And that is exactly why this matters so much if you are over 60, over 65, nearing retirement, already collecting, or helping a spouse, parent, brother, sister, or close friend make one of the most important money decisions of their lives. Social Security is not just another government program sitting in the background. For millions of older Americans, it is the difference between breathing room and panic, between paying the utility bill on time and falling behind, between protecting a lifetime of work and watching monthly income come in smaller than expected. So let me ask you something right now. Were you ever told that you could take a spousal benefit first, delay your own benefit until 70, and then switch later to a bigger check? And if you were told that, are you absolutely sure that advice still applies to you in 2025? Because this is where so many good people get tripped up. They hear one sentence from a neighbor, one half-correct tip from a family member, one outdated video online, or one old article shared on social media, and suddenly they believe a powerful loophole is still there for everyone. It is not. And when people find out after they already claimed, the feeling is brutal. It is not just disappointment, it is regret. It is that sinking feeling in your stomach when you realize one form, one filing date, one misunderstood rule may have locked in a lower strategy than you expected. So let's break this down in plain English, because the government language around Social Security can make even smart people feel like they are reading a foreign instruction manual. Years ago, there was a strategy that allowed some married couples to increase their total lifetime household benefits. In simple terms, one spouse could sometimes claim a spousal benefit while delaying their own retirement benefit, letting that personal benefit keep growing through delayed retirement credits until age 70. That mattered because the longer you delay your own retirement benefit after full retirement age, up to age 70, the bigger that benefit can become. People loved this strategy because it created a kind of two-track system. Money could come into the household now, while the future check kept getting stronger. Sounds powerful, right? It was. For the people who qualified, it could mean real money over time. And that is why people still talk about it in whispers like it is some hidden code or insider secret. But here is the part many viewers miss. Congress already moved to shut down the core of that strategy years ago, and by 2025, the people who were still grandfathered under the old rules have effectively aged out of the most talked about version of it. In other words, a lot of seniors in 2025 are not discovering a fresh loophole. They are discovering that an old loophole they heard about is no longer available to them. Now ask yourself this: how many people do you know who are still planning retirement using advice that was technically correct once, but is no longer correct now? How many people are walking around with a 2014 or 2015 Social Security strategy in their head and thinking it still works the same way today? That is the danger. Not bad intentions, not laziness, outdated information. Here is what happened. Congress changed the rules in the Bipartisan Budget Act of 2015, and two major pieces of the old playbook were hit hard. The first piece involved what is often called restricted application or deemed filing rules. The second involved what people called file and suspend. Those phrases sound technical, but the impact is simple. The government tightened the rules so couples could no longer double dip in the way they once could, collecting one type of benefit while also building up extra delayed credits on another benefit in the background. Let me make that even easier to understand. Under the old setup, some people at full retirement age could file specifically for a spousal benefit only and hold off on claiming their own retirement benefit. That allowed their own benefit to keep growing. Later, they could switch to that larger benefit. Congress changed that. For most people, if you are eligible for both your own retirement benefit and a spousal benefit, filing for one means you are generally treated as filing for both. Social Security pays essentially the higher applicable amount under the rules, rather than letting you cleanly separate the two, the way some people once could. That one change alone crushed a strategy that older articles still describe like it is a live option for everybody. Then came the other major hit, file and suspend. Under that old maneuver, one spouse could file for benefits and then voluntarily suspend them, which under the old rules could trigger spousal benefits for the other spouse while the first spouse's own benefit kept growing. Congress changed that too. For suspensions requested after the rule change took effect, if the worker's benefit is suspended, benefits payable on that record are generally suspended as well. In plain English, that means the trick stopped working the way many couples had hoped. And this is where the title of this video becomes painfully relevant, because in 2025, a lot of people are only now realizing the loophole is effectively gone for them. Why? Because there was a grandfathering element. Some people who were born before January 2nd, 1954, were protected under the older restricted application rules if they met certain conditions. But by 2025, that group is already past the ages where most viewers are making that first major claim decision. So even though the legal change did not happen in 2025, the practical reality hitting many households in 2025 is the same. The strategy they thought they could use is no longer there for them. And I want you to really sit with that for a second. If you are 62, 63, 64, 65, 66, or even a little older and you were counting on that old spousal first, switch later strategy, did you actually verify whether you were born early enough to be grandfathered? Did you confirm whether your claim falls under today's deemed filing rules? Did you check whether someone gave you advice based on a loophole that ended for almost everyone already? Or are you still holding on to a plan that sounded smart because it used to be smart? This is where retirement planning gets emotional. People don't just lose money from bad investments. Sometimes they lose money from assumptions, from timing mistakes, from trusting that the system still works the way it worked for their older cousin, their retired neighbor, or the person they met at church who filed 10 years ago under a completely different set of rules. And the government is not going to chase you down and say, hold on, before you file, let's make sure you are not relying on a strategy that expired. That burden falls on you, on your household, on the questions you ask before you sign anything. Now let's be very clear, because I do not want this video creating confusion. There are still exceptions and special situations. Widows and widowers can have different claiming flexibility with survivor benefits. Some disability situations work differently. Certain caregiving situations work differently. Divorced spouses can involve special rules too. So this is not a blanket statement that every person in America has the exact same Social Security choices. That would be irresponsible. But for the classic married couple loophole, most people are talking about when they say, can I take the spousal benefit first and let my own check grow? That strategy is largely closed off to newer claimants. And here is another reason this subject is blowing up in 2025. There is a separate Social Security change that really did happen in 2025, and many people are mixing the two stories together. The Social Security Fairness Act was signed into law in early 2025, and that law repealed the windfall elimination provision and the government pension offset. That was a very big development for certain public pension retirees, including many teachers, firefighters, police officers, and other workers whose Social Security benefits had been reduced because of pensions from work not covered by Social Security. That is real. That is major. But it is not the same thing as reopening the old married couple loophole. In fact, if anything, this is where confusion gets dangerous. One 2025 change helped some retirees. It did not revive the old spousal claiming trick for everyone else. So if you heard someone say, Congress changed Social Security in 2025, there is a loophole now, or there is a loophole gone now, slow down and separate the stories. Ask, are we talking about WEP and GPO being repealed for certain public pension workers? Or are we talking about the old restricted application and file-and-suspend strategies that Congress shut down years earlier and that most people can no longer use? Those are not the same conversation, and mixing them up can lead you straight into a costly filing mistake. Let me put this where it hits home. Imagine a married couple both nearing retirement. One spouse earns a stronger worker benefit. The other assumes they can start collecting a spousal benefit at full retirement age while waiting on their own record to grow until 70. They build that expectation into their budget. They maybe delay part-time work. Maybe they decide not to draw down savings yet because they believe that extra Social Security flexibility is still available. Then they find out the rules changed, they do not qualify under the grandfathered group, and the plan they were depending on never really existed for them in the first place. That is not a small inconvenience. That can reshape the next 5, 10, or 15 years of their retirement income planning. And this is why the people who stay calm, informed, and proactive win. Not the people who panic, not the people who rush to file because someone told them Social Security is running out tomorrow. Not the people who freeze because the rules sound complicated. The people who win are the ones who stop, verify, and ask the right questions before they claim. So here are the questions you need to ask yourself right now, and I want you to answer them honestly. Have you already filed for Social Security, yes or no? If yes, did you file based on a strategy you fully understood, or did you file because you were afraid of missing out? If no, are you still depending on a loophole that does not actually apply to your birth year? Are you married, divorced, widowed, or single? And do you understand which category matters under the rules? Do you have a government pension from non-covered work that may now be affected by the 2025 Social Security Fairness Act? Have you created a My Social Security account and reviewed your earnings record for mistakes? When was the last time you checked that record? Last month, last year, or never? Because let me tell you something most people do not want to hear. A Social Security mistake is not always dramatic in the moment. It can be quiet. It can look harmless. It can look like one decision made in a 5-minute phone call or one online application, submitted without fully understanding the long-term consequences. Then years later, that quiet mistake becomes a very loud financial problem. Now some viewers will say, fine, if the loophole is gone, what am I supposed to do instead? And that is the right question. The answer is not to give up. The answer is to shift from gimmicks to strategy. First, understand your full retirement age. That number matters. Claiming before it can permanently reduce your monthly benefit. Waiting beyond it, up to age 70, can increase your own retirement benefit if you are entitled to delayed retirement credits. Second, understand the role of spousal benefits versus your own worker benefit. Many people think they are choosing between two completely separate checks they can stack however they want. That is not how it works for most people under current law. Third, if you are widowed, divorced, disabled, or affected by a public pension, do not assume the generic advice online applies to you. Your category matters enormously. Fourth, if you or your spouse worked in a job not covered by Social Security and receive a public pension, pay close attention to the 2025 Fairness Law, because that change may help you in a real way. If your benefits were previously reduced by WEP or GPO, your situation could be different now than it was just a year ago. And that is exactly why blanket advice is so dangerous. One older rule closed a door for many married couples. Another newer law opened relief for many public pension retirees. One household may be hurt by outdated assumptions. Another household may benefit from a change they have not even realized yet. Can you see why this topic causes so much confusion? On one side, people hear the word loophole and think opportunity. On the other side, they hear Congress and think threat. Then somebody throws in 2025 changes, fairness, pensions, spouse benefits, survivor benefits, delayed credits, and suddenly people feel overwhelmed. But you do not need to be overwhelmed. You just need to stop taking shortcuts with retirement information. Let me ask you another direct question. If your next Social Security decision could affect your income for the rest of your life, Why would you rely on a 30-second clip from social media? Why would you trust a casual comment from someone whose age, marital status, work history, and pension history are completely different from yours? Why would you assume the government formula that applied to one person in 2014 automatically applies to you in 2025 or 2026? Your retirement is too important for that. And here is the emotional truth that a lot of people feel but do not say out loud. Many seniors are tired. Tired of inflation. Tired of policy changes. Tired of hearing that they should have known one more rule, watched one more deadline, read one more fine print explanation. I understand that. You worked your whole life. You paid in. You should not need a law degree to understand how to protect your own benefit. But since the system is complicated, the best defense is clarity. That is exactly why conversations like this matter. So if you are watching this and feeling a little angry, a little nervous, or even a little embarrassed because you thought that old loophole still existed, please hear me clearly. You are not foolish. You are not alone. The rules really did change, and too many people online still talk about these strategies without clearly explaining the grandfathering, the timelines, and the exceptions. What matters now is not blame. What matters now is your next move. Your next move is to review your claiming strategy before you file or before your spouse files. Your next move is to make sure your Social Security earnings record is accurate. Your next move is to identify whether you are dealing with a standard retirement claim, a spousal claim, a survivor claim, a divorced spouse claim, or a pension-related case affected by the 2025 Fairness Law. Your next move is to stop assuming and start verifying. And if you have already filed, do not just click away and assume this video no longer matters. Ask yourself, did I file at the right time? Did my spouse and I coordinate correctly? Am I entitled to any other benefit category I overlooked? If I receive or expect a public pension, could the 2025 Fairness Law change what I should receive? If I am widowed, have I fully reviewed survivor options? If I am divorced after a long marriage, have I checked whether divorced spouse benefits could matter? Sometimes the biggest money mistake is not a bad claim. Sometimes it is failing to revisit the situation when the law changes. This is also a moment to talk about urgency without panic. Yes, you need to act. No, you do not need to act recklessly. There is a big difference. Urgency means reviewing your plan now, not 6 months from now. Urgency means checking the facts before making an irreversible decision. Urgency means talking with the right sources, understanding your category, and making sure your household is not relying on yesterday's loophole or missing today's opportunity. Panic means filing too early because a headline scared you. Panic means making permanent decisions because somebody online yelled that the system is collapsing. Don't do that. If this video saved you from one misunderstanding, then let me give you the simplest summary possible. The famous married couple Social Security loophole that lets certain people take one benefit while letting another grow has been largely shut down for modern claimants. The old grandfathered pathway applied only to an earlier birth group, and by 2025, most people hearing about it are hearing about it too late to use it. At the same time, a real 2025 law, the Social Security Fairness Act, changed benefits for certain public pension retirees by repealing WEP and GPO. Those are two different stories. If you confuse them, you risk making the wrong move. So here is what I want you to do next, and I want you to take this seriously. Tonight, not next week, log in and review your Social Security record. Look at your estimated benefit amounts. Look at your earnings history. If you are married, sit down with your spouse and talk through your claiming plan together, not separately. If one of you had non-covered public employment, flag that immediately. If you are widowed or divorced, do not assume the ordinary married couple rule tells your whole story. And before you file anything, make sure the strategy in your head matches the law as it stands now, not the law as it existed a decade ago. And now I want to hear from you directly because this conversation matters. Had you heard of file and suspend before today? Did you think restricted applications still worked for most people? Have you or your spouse already filed based on advice that may have been outdated? Are you one of the retirees affected by the 2025 Fairness Law for public pensions? Tell me in the comments, because your question could help someone else avoid a major mistake. If you want more clear, no-nonsense updates that protect your Social Security, retirement income, senior benefits, and the money you spent a lifetime building, stay with Federal Benefits Guide, because this channel is here for one reason: to help you cut through the noise before misinformation costs you real dollars. Subscribe, turn on notifications, and share this with one person over 60 who still thinks that old loophole is sitting there waiting to be claimed. Because the truth is simple: the sooner you know which doors are closed, the faster you can focus on the ones that are still open, and that is how you protect your future instead of reacting to it after the damage is done.